whatever time we have left, let's discuss summation and how that differs from opening statements.
Well, before summation, you do the legal instructions which the judge gives, which are, they're all the instructions that you're going to touch on after in summation. Because if you have justification, which is self-defense, you can get that, the defense of yourself, when somebody attacks you, you can attack them back, or the defense of others. If somebody's attacking you, I can attack them to save him. That's what it is.
Good.
It's the defense of others. So that you discuss with the judge all these instructions, and you discuss them, and they're like, okay, they're going to be given to the jury. And then summation starts.
Just the idea is that there's like a conversation that it involves the defense, right? The client's there, the prosecutor, and the judge, in which you guys agree that there's going to be instructions that's going to be given to the jury that you will know ahead of time what they are, so you can tailor your summation to those instructions.
Yes, and you know what? And that's actually great, because you do this outside the presence of the jury.
Yes.
Because there's some instructions that can actually be argued for, and they're never given.
Yes.
So
why
you
is
do that outside
they can taint the jury.
because they can taint the jury. So you do that outside the presence of the jury, like you said, and then the summation, you should know already what instructions are going to come in, what are not, and then you just tailor your summation, like you said, to the jury instructions. And your summation is you can refer to anything that was mentioned in the case. And you can be persuasive, and you can be argumentative, which is one of the things that they don't allow. Meaning you can argue, okay, you saw this, so that is what, like that. You can argue in summation. In opening statement, you cannot argue. You can only tell them, okay, this is what the evidence will show. This is what the evidence will show. And DAs do that a lot. In summation, you just go, the evidence said this, thus that. That's, as defense attorneys, what we do. DAs also do that. The evidence showed this, so I met this element, because of this and that, and that's how a summation is. You can refer to the trial itself, but that's not evidence.
I think the best analogy I ever heard of a summation is this concept, right? That you spend the whole trial developing the building blocks to whatever you want to build, right? Like you develop the evidence, and only during the summation do you start to put it together and go, look at all these elements, all these building blocks. I'm gonna build you a not guilty, or I'm gonna build you a guilty, like a house. You know what I mean? And then it's like the person who builds the most clearest, most like I can see that picture so clearly based on the combination of all these things that was established in the trial.
I like that, but I don't like that, because you're putting yourself. You're saying you have a job of building, and you don't have a job of building shit in this criminal justice system. You shouldn't.
You shouldn't. Right. But you do.
You shouldn't.
I mean,
but we shouldn't conform to that.
Well,
we shouldn't conform to, like, just because they're building and we have to build, and that's you don't break that wall down.
This is what I would say, right? I think you're right. You don't, right? And I think.
But I
think this kind of goes to what we said in the beginning, which is that trials are a scary place to be at, whether you're innocent or not, because the scary, the terrifying thing that can happen at a trial is that everything can go your way, right? In terms of how you think this shit should shake out, and then you know what happens? You got a prosecutor who's make it nasty, fire prosecutor, persuasive, and he puts these pieces together, and they shouldn't add up to shit. And he's fucking the Van Gogh of fucking closing arguments. And he just makes it look beautiful. He makes it look natural. And then you have not necessarily a shitty defense attorney, but someone who just, his message gets lost in the sauce. And he doesn't take these, what should be a not guilty, he doesn't piece it together and leave the jury with a persuasive argument. And the jury believes the wrong thing more than they believe the right thing. Right? I mean, that's what terrifies me about the process.
It's because it's a totally coin, bro.
It's art. I mean, trials are art.
It is. You're right in a way. It is.
There's so many things we don't
I'm gonna tell you
control.
what it is. Like, it's plain and simple words. Like a trial's like a story. Because when you start, you tell them what you're gonna tell them. You don't go in depth, but you tell them what you're gonna tell them. You tell them during the trial, and then in summation, you tell them what you told them. Boom. It's just like a paintbrush. That's what it is. But just can't lose track of trust that, and just the mindset that you don't have a job here. It's the DA, and it's very difficult, as you guys said, to get the jury to know and get in their mindset that that's the case. It's very difficult. Super, super difficult. And, you know, as defense attorneys, that's what we have to do. And as prosecutors, they have to build their case. And at the end of the day, you can only hope that the jury gets it right.
My only thing about trials is, right, like I obsess about my trials. Right? If I have a client, I have a civil case or criminal case, I'm constantly thinking about it. And even as attorneys, we might bounce ideas off each other. I'm like, yo, how do you think a jury would perceive this or perceive that? And like, it's very frustrating because you try to think of everything. Then after you get a verdict and you speak to a juror and they're like,
oh, that shit you thought was important wasn't that important.
Yeah, it wasn't.
Or why didn't you talk about this? Or I wish you spoke about that. It's like we obsess about things so much as attorneys, trial attorneys.
That's
like
a fact.
We're trying to like compensate for everything you're thinking about.
Yeah.
You know, I was like, well, we were waiting for you to ask him this question. And like, just like we spoke about, we don't know what he's gonna say. Or there might have been a ruling by the judge that you can't say that. You can't talk about anything about that. But that's something.
I think there's something very dangerous about trials, which is why I take a lot of discounts. Which is that it's perception's reality, right? In life and in trials, and the perception of what they saw, the jury, right? What they perceive to have happened is going to be the determiner of what happened for this person's life, your client. Then what happened, right? Because you weren't there.
Yeah, they're not
The jury wasn't there. So it's about what they think happened, not what actually happened. A trial is not the determiner of truth. It's the determiner of what a jury thinks is the truth.
Yeah.